From last week's Civil Justice Committee hearing on House Bill 1005, the full parade of administration big guns showed up to attempt to defeat this restorative legislation. It seeks to return the rights to the type of arms Tennesseans had in 1796. It adds nothing our founders did not recognize as God-given rights at our beginning. Government does not give you your rights. They can, however, be taken away by it. Most notable of these liaisons was the director of the TBI, David B. Rauch, a career policeman now at the apex of Tennessee law enforcement. His rendition of what the Second Amendment means and the power it gives to the people and what power he thinks the government has are at odds with what we at the Tennessee Firearms Association understand them to be. He tells us, as you will see in the video taken from the .gov website, that he has thoroughly read the recent Bruin decision. If so, I suggest he do so again. He agrees that the Bruin decision rests on Scalia's treatment of the right to arms in Heller. What is not mentioned is the McDonald v. City of Chicago decision from 2010, which incorporates or binds the states under the same rule as the federal government through the Due Process Clause of the 14th Amendment, shall not infringe, making the second a civil right for every citizen of the United States. Scalia identified the only thing that was to be regulated via the second was the militia, not the right itself. Yet our TBI director states time and again that the power belongs to the states to withhold the right to arms, saying it is theirs to decide when, where, how, and what constitutes permissible arms for Tennesseans. His testimony is instructive as to what our governor intends for us to have, as he is the director's boss, and each of the functionaries present speaks with his voice. We will hear today from the TBI, and later the others who came on your dime to stand between you and your rights won by sacrifice of blood and treasure by our forebears.
Thank you, Mr. Chairman. My question is for Director Rauch. Thank you for being here. Specifically, I want to ask you questions about the Second Amendment, Heller, and the Bruin decision, because you obviously raised both Bruin and Heller in your comments, Director. First, you agree that this committee has to act in accordance with the Second Amendment, correct?
And thank you.
Yes, sir. And I think here's what we can do. If y'all can just have, I'm not going to recognize you guys every time, so I know you all will be respectful. Everybody in this committee will be respectful of every person down there. So,
thank you, Chairman. Yes, sir. I would agree that following the Second Amendment, but also following the rulings of the Supreme Court, who provides us the guidance in law enforcement on the application of the Second Amendment.
Sure.
So you have as well, and so to look and to point to the constitutional question, I think is important. I have read thoroughly through the New York case on Bruin, and as I've read through that, Justice Thomas was very clear in his response. This was about handguns. It wasn't about long guns. The New York case is about handguns. He made it very clear in his response that they were holding their ruling consistent with the Heller case, which is the District of Columbia versus Heller, another Supreme Court case that has set the standard for states to make regulation on firearms. And that standard is reasonable regulation. And so what we're asking is that reasonable regulation be recognized in the state of Tennessee. And so the court still recognizes that states have the authority to reasonably regulate firearms and the manner that they are carried and where they are carried and how they're carried and when they can be carried. That is recognized continuously by the Supreme Court.
From District of Columbia, et al. V. Heller, 554 U.S. 570, 581-82, 2008. Some have made the argument, bordering on the frivolous, that only those arms in existence in the 18th century are protected by the Second Amendment. We do not interpret constitutional rights that way, just as the First Amendment protects modern forms of communication, for instance, Reno versus American Civil Liberties Union, and the Fourth Amendment applies to modern forms of speech, for instance, Kylo v. United States. The Second Amendment extends prima facie to all instruments that constitute bearable arms, even those that were not in existence at the time of the founding.
Sure, and Justice Thomas and Bruin relied heavily on Justice Scalia's opinion in Heller, correct?
That's absolutely correct.
And one of the things that Justice Scalia focused on in Heller was that the Second Amendment is comprised of two clauses, a prefatory clause and an operative clause, correct?
Correct.
And the prefatory clause is, quote, a well-regulated militia being necessary to the security of a free state, close quote, correct?
Close.
That's the prefatory clause. When you say close, have I missed it somewhere?
No, I think that's a close. I think that's
Sure.
a close quote.
Okay.
I don't
Well-
know its exact, but
Well, the full Second
it's
Amendment
close.
says a well-regulated militia being necessary to the security of a free state, comma, the right of the people to keep and bear arms shall not be infringed, correct?
Absolutely.
And you understand that what the Second Amendment was doing was not creating a right, but rather codifying a pre-existing right, correct?
Correct.
And in Heller, Justice Scalia said that based on the prefatory clause, it's clear that the weapons that the Second Amendment had in mind and that the framers had in mind were weapons that were commonly in use at the time, correct?
That's correct.
And so he very specifically said that the kinds of weapons that one has an individual right to own are the same kinds of weapons used in the militia, correct?
I'm not sure that he dug into that.
Okay,
I'm not
well-
sure he went that far.
Well, I mean, I can quote from the opinion, section 3 of his
I
opinion.
think he was talking about muskets, if I.
Again, from Heller. In the colonial and Revolutionary War area, small arms, weapons used by militiamen, and weapons used in defense of person and home were one and the same. Cited from State v. Kessler, citing G. Newman, Swords and Blades of the American Revolution. It may be objected that if weapons that are most useful in military service, M16 rifles, and the like, may be banned, then the Second Amendment right is completely detached from the prefatory clause. But, as we have said, the conception of the militia at the time of the Second Amendment's ratification was the body of all citizens capable of military service, who would bring the sorts of lawful weapons that they possessed at home to military duty. It may well be true that today that a militia, to be as effective as militias in the 18th century, would require sophisticated arms that are highly unusual in society at large. I must commend Representative Bolso on his calm demeanor and his excellent handling of the questioning. He is an attorney and comports himself admirably on our behalf. No conjecture, as the old saw goes, just facts. In closing, it is obvious that one of two things is so. Director Rauch is lacking in knowledge of the Second Amendment, or he thinks we are. The closing credits to this video will be two pictures taken that day, one of me surrounded by a sea of Moms Demand Action advocates, with me the lone Second Amendment supporter, and a snapshot of the director at the end of the committee. He received accolades from the Moms Demand Action group, and I felt it auspicious to share these photos I was sent. Awash in a sea of foes. Evidently, where his heart is.